Hello LiveLaw viewers, welcome to Courts Today. Let us dive into important legal headlines of the day. The Supreme Court has held that BNSS or CRPC provisions on rights of arrested persons are applicable to GST and Customs Acts. Allahabad High Court has ordered ASI inspection of the Sambhal Mosque to assess need for whitewashing ahead of Ramzan. The Apex Court has sought centre's response on compensation for those who died due to COVID vaccination adverse effects. The top court has refused to halt disposal of chemical waste from Bhopal gas tragedy at Pithampur. Saying that deaths due to manual scavenging expose claims, the Supreme Court has sought explanation from Delhi, Kolkata and Hyderabad authorities. Centre has opposed a plea in the Supreme Court to impose life ban on convicted politicians and said that the matter is purely within parliamentary domain. And the Kerala High Court has directed Kerala State Legal Services Authority to obtain grievances, suggestions from inhabitants living in human-animal conflict areas. I'm your host Urvashi Chauhan, coming to you with the important legal updates of today, quick, crisp and to the point. Watch this video till the end, and if you find this update valuable, please do not forget to like, share and subscribe to our channel. Your support keeps us going. The Supreme Court today delivered an important ruling on the powers of arrest under the Goods and Services Tax Act and the Customs Act. The court held that provisions of CRPC, which is now Bharatiya Nagrik Suraksha Sanhita, on the rights of accused persons are equally applicable to the arrests made both under Customs Act and the GST Act. It held that principles laid down in the Arvind Kejriwal case regarding arrests under PMLA also apply to GST and customs arrests. The court noted that Section 19(1) of PMLA and Section 104 of Customs Act are virtually the same. Both provisions deal with the power of arrest. The court extended this reasoning to arrests under GST Act as well. It also held that circulars issued by GST Department regarding arrest must be strictly adhered to. The court also rejected the argument that customs officers are police officers. It further held that provisions relating to anticipatory bail are applicable to the GST Act and Customs Act, and the parties can approach the court for relief if there is an apprehension of arrest without the FIR being registered. A bench of Chief Justice of India Sanjeev Khanna and Justices M.M. Sundaresh and Bela M. Trivedi made these observations while delivering the verdict in a batch of 279 petitions challenging the penal provisions in the Customs Act, CGST and SGST Act, etc. A bench of Chief Justice of India Sanjeev Khanna and Justices M.M. Sundaresh and Bela M. Trivedi made these observations while delivering verdict in a batch of 279 petitions challenging penal provisions in Customs Act, CGST, SGST Act, etc. as non-compatible with CRPC and the Constitution. There are two judgments delivered, one by CJI Khanna and a concurring judgment by Justice Trivedi. Justice Trivedi's judgment deals with the powers of judicial review. To read the judgment in detail, please visit livelaw.in. In the next update, the Allahabad High Court has directed Archaeological Survey of India to inspect the Shahi Jama Mosque in Sambhal and assess the need for whitewashing and other maintenance work ahead of the holy month of Ramzan, which starts on 1st March. The court has ordered ASI to submit its report by 10 a.m. tomorrow. The order was passed by Justice Rohit Ranjan Agarwal while dealing with an application filed by the management committee of the mosque. The committee had challenged objections raised by authorities regarding the routine upkeep of the mosque, which they say is necessary to ensure a smooth experience for people during Ramzan. The dispute arose after ASP of Sambhal objected to the committee's maintenance plans, citing that the mosque is a protected monument under the ASI. The ASP stated that permission from ASI was required before carrying out any work on the premises. However, the committee argued that such maintenance activities, including whitewashing, cleaning and lighting installations, have been carried out every year without interference from authorities. During the hearing, senior advocate SFA Naqvi, appearing for the mosque committee, submitted that ASI itself is responsible for the upkeep of the structure, yet it was objecting to the mosque's own efforts to carry out necessary maintenance. On the other hand, ASI's counsel advocate Manoj Kumar Singh contended that officials had been denied access to the premises, preventing them from inspecting the site. The application of the mosque committee was also opposed by advocate Hari Shankar Jain, who argued that maintenance work might lead to defacement of Hindu artifacts allegedly present inside the mosque. In response, the bench assured that this concern would be taken into consideration. To address the matter, the court has constituted a 3-member ASI team which will visit the mosque and submit its report. The bench emphasized that maintaining communal harmony during Ramzan is of utmost importance. After the order was dictated, ASI's counsel requested the court to provide security for the inspection team. However, the court dismissed the request, stating that it was unnecessary. The Apex Court has directed the Additional Solicitor General Aishwarya Bhati to seek instructions from Union Government on whether it intends to formulate a compensation policy for families of individuals who allegedly died due to COVID-19 vaccination-related adverse effects. Adverse effects following immunization, or AEFI, refers to any unexpected medical occurrence that happens after a person receives a vaccine. A bench comprising Justices Vikram Nath and Sandeep Mehta was hearing a special leave petition filed by Union of India against an interim order of the Kerala High Court. Now, what is the whole matter about? A writ petition was filed by a woman before the Kerala High Court seeking ex gratia compensation for the death of her husband, who allegedly died due to AEFI following a COVID-19 vaccination. The High Court issued an interim order directing the Ministry of Health and Family Welfare and National Disaster Management Authority to frame a compensation policy within 3 months for individuals who died due to AEFI. The Union of India challenged this order by filing a review petition. It argued that vaccination was a voluntary act and taken at the individual's discretion. It also contended that AEFI cases do not qualify as a disaster under Section 12D read with Section 2D of Disaster Management Act, meaning statutory compensation is not applicable, and that Kerala High Court should not have passed the interim order, as a similar matter titled Rachna Gangu versus Union of India is pending before the Supreme Court. However, during the pendency of this review petition in the High Court, a contempt petition was filed for non-compliance with High Court's interim order. The High Court issued notice on the contempt petition, and now, assailing that order, the Union government has filed the present SLP before the Supreme Court. The Union has also sought to transfer the matter from Kerala High Court to Supreme Court to be heard alongside the other similar matter. Also, let me tell you, in the Rachna Gangu case, the Union government has already filed an affidavit maintaining that it cannot be held liable for deaths resulting from COVID-19 vaccination. The present SLP will now be heard on 18th March. Stay tuned. In the next update, the Supreme Court today refused to interfere with the direction of the Madhya Pradesh High Court, which ordered disposal of chemical waste from Bhopal gas tragedy site to Pithampur. In December last year, the MP High Court criticized the prolonged inaction regarding failure to clear the toxic waste still lying at the Union Carbide factory site even 40 years after the 1984 Bhopal gas tragedy, and ordered an immediate cleanup. The High Court had ordered a trial run of 10 metric tons of waste. However, concerns were raised about disposal of the 337 metric tons of hazardous waste to Pithampur facility because of its proximity to human settlement and a nearby river. Earlier this week, the top court had asked the state to show that adequate precautions have been taken and present concrete proof of safety measures before proceeding. During the hearing today, one of the counsel representing the victims of Bhopal gas tragedy said that the plant does not monitor certain toxic gases as they are not required under the rules. He added that organization has a better alternative solution which it wishes to present to the court. Senior advocate Devdutt Kamath today informed the bench of Justices B.R. Gawai and A.G. Masih that the High Court had set up a task force committee with 15 technical members to examine the entire issue of waste disposal. He highlighted that following Supreme Court orders in 2013 and 2015, 2 trial runs were conducted and both were successful. Calling it a very serious issue, he also pointed out that while it was initially claimed that 11 public representatives had agreed to the measures, 8 of them later approached the court denying that they had never given their consent. Further, he also pointed out the discrepancy in the test reports submitted before the court, stating that the reports appeared to be from another private plant and not from UCIL. The court was also informed that the matter is being actively handled by the High Court through a task force committee. The court noted that the task force committee, constituted by the High Court, consisted of high-level technical expert bodies like National Environment Engineering Research Institute and National Geophysical Research Institute and Central Pollution Control Board. The top court then concluded that given the involvement of expert bodies and the High Court's active engagement in the matter, there was no need for intervention at this stage. The bench, however, allowed the concerned parties to present their grievances before the High Court if needed. The Apex Court has expressed a strong dissatisfaction with the affidavits filed by authorities in Kolkata, Delhi and Hyderabad, criticizing them for failing to provide a clear timeline and action plan for ending manual scavenging and manual sewer cleaning in their cities. The court noted that despite claims by Delhi Jal Board, Kolkata Municipal Corporation and Hyderabad Metropolitan Water and Sewage Board, these hazardous practices had been eradicated, deaths due to manual scavenging continue to occur. The bench of Justices Sudhanshu Dholia and Arvind Kumar, while reviewing the compliance of its earlier order, raised concerns over the absence of specific details regarding measures taken to prevent such fatalities. The court pointed out the contradiction in the authorities' claims and the ongoing loss of lives, questioning how these deaths occurred if manual scavenging had truly ended. Last month, the top court had passed directions banning manual scavenging and manual sewer cleaning in 6 major metropolitan cities, namely Delhi, Mumbai, Kolkata, Chennai, Bangalore and Hyderabad. This was in a writ petition seeking complete eradication of the practice across India. Following this order, the chief executive officers of these cities were required to submit affidavits detailing how and when manual scavenging had been eliminated in their respective jurisdictions. Despite these directions, Bengaluru failed to submit its affidavit. The court has now summoned authorities from Bengaluru, Kolkata, Delhi and Hyderabad to appear in court in the next hearing. Additionally, the court has sought an explanation from all responsible authorities as to why criminal prosecution should not be initiated against officials or contractors who either directly employed manual scavengers or were responsible for deaths occurring under their supervision. Moving ahead, the union government has filed a counter affidavit in the Supreme Court opposing a petition that seeks permanent ban on politicians from contesting elections after being convicted in criminal cases. The affidavit has been filed in response to a petition filed by lawyer Ashwini Upadhyay in 2016 challenging constitutional validity of sections 8 and 9 of Representation of People Act 1951. 2 weeks ago, Justice Dipankar Datta and Justice Manmohan had sought response of the union government on the issue. The bench had orally observed that there was an element of conflict of interest as the politicians themselves were making the laws. The government has now said that the period of disqualification is a matter which is purely within the domain of legislative policy. For your understanding, let me tell you, as per Section 8, a person who has been sentenced for the offences specified in this section shall be disqualified from contesting elections for a period of 6 years after serving the jail term. As per Section 9 of the Representation of People Act, public servants who are dismissed for corruption or disloyalty to the state are disqualified from contesting elections for 5 years from the date of their dismissal. The petitioner here demands that disqualification should be for a life term. The centre has said that the question whether a lifetime ban would be appropriate or not is a question that is solely within the domain of the Parliament. That the term of disqualification is determined by the Parliament considering the principles of proportionality and reasonability. The centre has defended the challenged provisions, stating that they are constitutionally sound and do not involve excessive delegation of power. It further argued that these provisions are within the legislative authority of the Parliament and do not violate constitutional principles. And lastly, the Kerala High Court has taken serious note of the ongoing human-animal conflict in the state and directed Kerala State Legal Services Authority to coordinate with district and taluk legal services authorities to conduct a survey of the issues faced by people living in affected areas. The court was hearing petitions from residents of various villages seeking government action to control the human-animal conflicts. The petitions also addressed compensation for the family of a man who died in a wild elephant attack in the year 2022. A single judge bench of Justice C.S. Dias observed that people living in hilly and and forested regions live in constant fear of wild animal attacks, which violates their fundamental rights. The court emphasized that mere compensation cannot truly make up for the lives lost and stressed the need for long-term solutions to prevent such tragedies. The court has instructed the Kerala State Legal Services Authority to inform residents about the compensation schemes available under central and state government programs. It was noted that 555 people in Kerala have lost their lives in wild animal attacks between 2019 and 2024. The government submitted that human-animal conflict is now classified as a state-specific disaster under the Disaster Management Act, and that both central and state governments are responsible for compensation. The petitioners argued that special tribunals should be set up to decide compensation claims fairly and efficiently. The court expressed disappointment over the lack of action despite earlier court orders. It has now suo motu added key officials as additional respondents in the case. The court has directed them to submit a report on the steps taken after the Joseph Tajet ruling from 2022 to reduce human-animal conflicts. It also instructed the Kerala State Legal Services Authority to file its survey report before the next hearing. With this, the matter was posted to 24th March.